Thank you.
So, Chair, I believe that we
Yeah.
do not have both parties on the first case right now in the waiting room. We do have both parties on the second case in the waiting room.
Can we just flip the order then and start with the second case and then move the first to later if the parties are not here? Is that agreeable? Okay. Then I will call this meeting to order of the City of West Hollywood Rent Stabilization Commission. If you will join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Mr. Secretary, can we have a roll call, please?
Commissioner Charity,
I'm here.
Commissioner Kirby's,
Here.
Commissioner Maggio is not present. Commissioner Martz,
Present.
Commissioner O'Keefe,
Present.
Vice Chair Topshin,
Here.
Chair Bergstein.
Here, we have a quorum. We got item 4, approval of the agenda. Do we want to approve the agenda, but with the slight shift to move? It would be D4494 to be the first appeal, and then D4430 the second appeal. Commissioners? I'll make that motion. Would somebody like to second it if you approve?
That.
We have a roll call vote on approving the revised agenda.
Commissioner Charity,
Yes.
Commissioner Kirby's,
Aye.
Commissioner Maggio is not present. Commissioner Martz,
Aye.
Commissioner O'Keefe,
Aye.
Vice Chair Topshin,
Aye.
Chair Bergstein.
Aye. The revised agenda pass. And moving on to item 5, the minutes from our September 10th, 2020 commission meeting. We all had a chance to review it. Do you have any revisions or corrections? Commissioner O'Keefe?
Yes, I had a change to the commissioner comments for the one where it says Commissioner O'Keefe proposed a discussion on amending regulations to allow the hearing examiner to suspend a rent reduction. The end of it to be more precise with what I proposed, I would say when a tenant is uncomfortable with repair work being done due to COVID-19, only in cases where the rent would otherwise be permanently restored.
Commissioners, are you in favor of that amendment to our minutes? Anybody have any objections?
I will make a motion to approve as amended.
Second?
Mr. Secretary, we have a roll call vote, please.
Commissioner Charity,
Aye.
Commissioner Kirby's,
Aye.
Commissioner Maggio not present. Commissioner Martz,
Aye.
Commissioner O'Keefe,
Aye.
Vice Chair Topshin,
Aye.
Chair Bergstein.
Aye, so the amended minutes are approved. Going on to item 6, Mr. Secretary, do we have any public speakers this evening?
Not at this time.
Okay, going on to item 7, manager's report, Mr. Noonan.
Good evening. I'd like to review your look ahead calendar at this time. For your next meeting on October 8th, we do have 2 cases scheduled for you. And in that case, there will be no additional discussion items or presentations. In your packet, we do not have any appeals scheduled for the October 22nd or November 12th meetings. However, after your packet was released, we did have 1 appeal scheduled for each of those nights. Therefore, we will break up the discussion items planned for October 22nd. We will provide the information on the RSO deposit interest formula that evening, and then shift the broken elevators discussion down to the next meeting with the information on subletting under the RSO on your December 10th meeting. And this concludes my report.
Okay. Commissioners, any questions for staff at this point? We'll move on to item 8, commissioner comments. I have one. I would like to propose an adjournment motion in the memory of Dr. Eugene H. Rogalski. Dr. Rogalski was a landlord since the 1970s, long since before West Hollywood was a city. He provided clean, affordable housing to probably thousands of tenants over the years. More importantly, Dr. Rogalski, along with his partner, were at the forefront of treatment for HIV patients in the early days. Their office was actually the first one to call the CDC and say, we're seeing strange diseases in pneumonia and otherwise healthy gay men. So they were the first ones to alert the CDC. He was an extraordinarily compassionate man that took care of so many of our brothers and sisters back in the day when most you could do was hope to give them a little bit of quality and hope that their death wasn't too poor. He was a wonderful landlord, 91 years old, died suddenly, unexpectedly at home, which is not a bad way to go. So I'd like to adjourn tonight's meeting in honor and memory of Dr. Eugene H. Rogalski. And with that, we will go on to our appeals. And since we have shifted the order, we're starting with D4494, which is 8221 DeLongpre. Can we bring the parties in, please?
Yes.
Thank you.
Hello, we had a shift in the order, and so we've brought in the second case first in case you're surprised by coming up so
No,
early.
no, thank you guys. Yeah,
You're
the
welcome.
sooner the better.
So I turn it over to Chair Bergstein.
So let me just explain how the process will work this evening. Our staff attorney, Ms. Regan, will make a report to the commissioners. The commissioners will have the opportunity to ask questions of staff at that point. After that, we'll begin with Mr. Cooper. As you filed the appeal, you have a total of 5 minutes. You can use your time all at once, or you can retain some time for rebuttal at the end. Just let us know when you begin speaking how you'd like to divide your time. For the tenant, Mr. Woods, you have 5 minutes total, no rebuttal time. I'd ask that when you begin speaking, each of you just for the record states your name and city of record. And with that, we'll go to our legal counsel, Ms. Regan.
Thank you, Chair. Good evening, Commissioners. My agenda packet is still loading, so I'm going to do this from memory. In this case, the tenant was granted a rent reduction for exterior paint and interior common area paint, as well as rent reductions for a pool stain and an odor. Staff is recommending that the Commission affirm in part and reverse in part the hearing examiner's decision, recommending affirming on the exterior paint and the interior common area paint. There was no dispute that the maintenance standards had not been adhered to for those two issues. With respect to the pool stain and the odor, staff is recommending that the Commission reverse the rent reductions on those issues. The hearing examiner used an improper standard that is not found within the RSO, and for that reason erred in the decision. Thank you.
Commissioners, do you have any questions for Ms. Regan at this time? Okay, so Mr. Woods, Mr. Cooper, you'll begin. Again, just state your name and city of record and let us know how you'd like to divide your time.
Sure, Charles Cooper, representing the landlord for Los Angeles, case number D4494. I will just begin with an opening statement, and then I can allot the rest of my time for any rebuttal that's necessary. If not necessary, I'm fine with my time.
Sure, go ahead, sir.
So we, Emmett Oaks, do agree with the staff report on the appeal regarding exterior paint, pool stains, and the building odor. We do, however, not agree with the hearing examiner's $7 rent reduction in regards to the claim for common area interior painting. We believe that we have complied with RSO and WeHo by completing an entire common area repaint. As evidence is presented with the two invoices that we've had, 2 separate occasions with painters to do the common area interior painting. Allegations that the paint is done in an inferior fashion or has deficiencies is speculative, and in my opinion, is a similar incorrect legal standard to the hearing examiner's allegation or claims to the pool staining, similarly to the actual paint not being done in the paint being done in an inferior fashion. So that's where we stand in regards to the interior paints. We believe it's a subjective standard not found in the RSO. And based on whether a tenant feels the paint job is done incorrectly by a licensed professional painter, and if the paint job is not good enough, it's subjective and not a proper standard. We as the landlord can only meet that by completing a full interior paint, which we've done with 2 separate occasions, and in-house paint touch-ups on any repairs that were made in the lobby area or anywhere else. So we do not also believe that the RSO states any specifications regarding the amounts of coat or the quality of paint. And it just requires that we repaint every 4 years, which we have complied with as evidenced by the money paid.
Commissioners, do you have any questions for Mr. Cooper at this time? None? So then, Mr. Woods, you can just state your name and city of record and you begin speaking. Mr. Wood, can you hear us? He was here
Hi,
earlier.
can you hear me now?
Yes.
Hi, thanks for having us here tonight. My name is Jimmy Wood, and I'm here in West Hollywood. I think basically I agree with Mr. Cooper. Well, one, I just wanted to bring up before I go any further is that on the initial hearing notice that was sent to me, it was actually, let's see, I'm looking up the photo regarding the appeal. It basically says that this appeal should have been made notice to me, okay, in the mail, all right, within the 10-day period. And this never got mailed to me, just FYI. And Mr. Cooper declared on here under oath that it was sent in standard mail. As you'll see, they checked off and then he circled standard, okay? That was not mailed to me. And it was on my door taped, just FYI. And I got back from helping an uncle. My uncle passed away from something in Texas. And I found this letter taped on my door. And that was in mid-June. I just want to bring that up to you. This is how they operate. And I have all my mail scanned by the United States Post Office. I get notifications of when mail comes and what's coming. So I was watching it while I was in Texas, and I never got a letter. I just want you to know that. And that was actually, I think, in my opinion, should invalidate this whole thing right now, because that was clearly perjury on that behalf, on Mr. Cooper's behalf on that. As far as everything else is concerned, they have stepped up to the plate, meaning that they were forced to, and they have done the majority of the things that were pretty bad and going on with this building that was in severe neglect. His letter is kind of looks like, I think it's actually a little bit very unprofessional, saying that I was like overstating stuff and blowing things out of proportion. That was not the truth. And this building was supposed to be painted, he doesn't even know the time frames. He doesn't even know how many apartments are in this building. So he's not even the manager. He's actually just an assistant. He stated he was the manager. A guy named John's the actual manager. But anyway, I wanted to let you guys know that they have done a lot of this stuff. And they painted the building. They didn't paint, some of the downspouts or the gutters are not painted, but they came in and they did paint up stuff. They redid the deck, although it's not really being managed very well. It's dirty. They don't clean it. So they have done these things that have been on this list. So so maybe they're not all to my standards, but they have been done. And Mr. Cooper's right. It's all subjective. So I guess really that's all I have to say. I don't, the odor is there because there's some old planters in the front of the building. I do have photos of some stuff that bricks are still laying broken in front of the entry right now as we speak, from the planter laying like in the hallway. But there's still the odor, and it's coming from the soot and the dirt that's in these planters that are on the interior of the building. It has to be. So that's probably where the mildewy smell comes from. The pool itself, if we're going through this stuff, it just, they don't have one of the little things, I'm forgetting the name of it, that cleans it constantly. So it's always turning yellow. And then, you know, they come and they treat it, they put some chemicals in it, and it kind of cleans it up. It's a little stained, yes. It's never been painted in the 20 years I've lived here, or drained. So I think that's part of some maintenance on swimming pools. But that's never been done. And I guess I get a little nervous. I'm sorry. It's because I had to go through this, and I didn't really want to have to do this, but I was standing up for the building just because I respect West Hollywood and this building. It's a nice little gym here. It's a mid-century modern building, and I don't like to see this kind of stuff neglected. So that's kind of why we're here. That's it. It's not because of greed and because I wanted cheaper rent. And that's all I have to say.
Commissioners, do you have any questions for Mr. Wood at this time? Then Mr. Cooper, Mr. Secretary, how much time does Mr. Cooper have remaining?
Yes, 3 minutes and 13 seconds.
Okay. Sir, if you'd like to make any rebuttal comments.
Yeah, thank you very much. So I'll just rebut a few of the things Mr. Wood said, and then just come back to my last closing argument here. In regards to delivering the appeal to Mr. Wood, we did deliver it properly. I'm not exactly sure how we would be seen as not delivering it properly. We did comply in all ways with West Hollywood. We did mail it out, we did email, and we did post it and deliver it correctly to Mr. Wood.
Nope, did not.
Mr. Wood, I'm sorry, you've had your time. Please don't interject at this point.
In regards to the claim I'm not the manager, I am the portfolio manager, representative of the entire company. I look over all the company's buildings, and I'm in charge of these type of proceedings. So I am qualified to be here. And I just wanted to bring up, the point that Mr. Wood made, that it is all subjective in a sense, because we as the landlord understand the point of this meeting, and the point of this committee and this entire process is to work with the tenants and to make sure that the building is upheld in a proper standard that meets the tenants' requirements, and also, as a landlord, that we're upkeeping it in a proper way. And we have tried to comply throughout this entire process with all the allegations that Mr. Wood has presented. In regards to the exterior painting, we've already placed a compliance determination request for foreman. We completed that on July 28th, a full exterior paint with the exact same licensed professional painter that did the common area interior painting. And it was done in a very professional fashion, and he is a professionally licensed vendor. And once again, just to bring up the point of subjective speculation, I think it's just hard for us as a landlord to, accept a rent reduction for something that we really have complied in doing. RSO authorizes rent reduction for the elimination or the decrease in the housing service. And when we were told that we had not completed the common area interior painting, we did 2 separate occasions, 2 separate invoices, and did complete a full common area interior painting, not only in the hallways and in the staircases, but also on the wood frame door frames, down into the garage, on the wood beams, and the top interior portions around the pool. So we as a landlord just feel that it's impossible for us to accept a $7 rent reduction for something that was, like in the pool staining allegation, an incorrect legal standard and completely speculative. There's no way for us to really cure this. In regards to Mr. Woods' comments about bricks and odor and the pool turning yellow, once again, we do upkeep the pool. We have regular pool cleanings. We have an active resident manager who upkeeps the common area. We have regular cleanings at the building. We really are, a very active landlord. We are putting money into this building. We are present. And we just feel that, the whole point of this type of committee is to really just meet halfway. And we felt that Mr. Woods has not really met us and continues to just speculatively and subjectively nag at the work that we've done. And there's really just no way to meet him.
Time, sir. Vice Chair Tufton.
Thank you, Chair. My question is for Mr. Cooper. I'm wondering if after the work was completed, did the management, the landlord, do kind of a walkthrough to see the quality of the work that
Yes,
was
sir.
done? And if you would have noticed something that was done in a sloppy way, maybe you could have asked them to redo that. So can you explain?
Yes, sir. We originally had our painters out in September of 2019 to do the first common area interior painting. The invoices in here, you can see 1,300, 550, and that was more of the wood beaming. And we had them come back and complete a second job of common area interior painting due to the fact that some areas did not meet our standards and other areas needed addressing. So we did call the painters back a second time. And in addition to that, our maintenance crew has done touch-up areas on any specific areas in the common area interior that we've done construction on. So I remember that there was a specific area in the lobby that was pulled off after the interior painting was done. We were doing some work in one of the tenants' shower pans and had to go through the wall. But once that work was completed, our crew immediately comes in and does touch-up painting on that actual spot and make sure that everything is set in standard. We do the walks consistently. We have units turning over in that building, so we constantly have our maintenance in there, looking around and making sure everything's in compliance.
Because what I see, one of the exhibits, exhibit 14, page 146 of our packet, it has a picture of what it appears is, I believe it's a door frame, a green color, but some of the paint is it appears on the wall. It's clearly, it's not sanded or properly painted. I wonder if you noticed that, if you have the same packet. I don't know.
I don't have the same packet in front of me. I do know which exhibit you're referring to, and like I said, that was one of the areas that we did have our painters come back to and readdress. We did walk the building the first time the common area was done, and certain areas like that had splotches or any type of misapplied paint, we did ask them to come back and reapply on their second job back. Additionally, our maintenance crew does look at the door frames consistently. So any kind of, miscue or error that would have been done in painting, they would definitely notify us, especially during this time when we've been constantly at the building and keeping an eye on everything and all the vendors that are coming in and out.
So you're saying that as of today, there is no, everything was fixed and there is nothing left?
I personally walked the whole building this week with my maintenance staff, and I checked all the door frames and everything.
I'm going to have to interrupt. This is going way beyond the record. We need to keep it to what was in front of the hearing
I
examiner.
apologize. Yes, sir. We did.
I would caution, I would caution commissioners to try not to ask questions that will elicit evidence that occurred after the hearing. Thank you.
Apologies. Yeah. Just
That's fine.
to not present new evidence. We did.
Thank you, Mr. Cooper.
Thank you, sir.
Thank you.
Yeah.
Thank you, Mr. Cooper.
Commissioners, any further questions for either party? And we will begin deliberations. Commissioner Charity?
I'm inclined to support the staff recommendation for the exterior paint and the interior paint. I think that was clear from what we heard today, that there's nothing in dispute with the exterior paint. The interior paint, if there was, evidence even so slight in front of the hearing examiner that it was insufficient or unpainted, then we're not here to reweigh that evidence. As far as the pool, I was a little bit split on that one in the sense of it is painting. We do have codified laws, 7 and 4 years for the exterior and interior paint, but we don't have anything codified for repainting a pool. So I'd be interested to hear what my other commissioners think about that one, but I am inclined to support the staff recommendation there. As far as the odor, all you can do with an odor is speculate where the odor is coming from. I don't know what we were looking for here. Are we looking for a sample from the planters? Will we remand this and look for them to bring in a sample of the odor? I'm not sure what we're looking for here. So I'll be interested to hear what my other commissioners have to say.
Mr. Kerpes?
I would agree with the staff recommendation in terms of, for discussion purposes, the pool I have no issue with due to the way the ordinance is written, but the smell, I don't see any issue with that as well. Smells come and go, and if it were mold or something like that, they could have had the county come out or somebody verify that it was mold. So since there is no evidence on that, and it's just speculation where the smell could be coming from, then I'm satisfied with I think we should reverse the hearing examiner's decision on that portion, just as the staff report recommends.
Commissioner Martz?
I would agree with Commissioner Kirby's and the staff report. I think the hearing examiner made errors that are being corrected in the staff's recommendation. And the paint on the interior does look like it still continues to have problems. And that's why the hearing examiner gave a partial and not a full reduction there. So I would support the staff's recommendation.
Commissioner O'Keefe?
I'd like to start with a question from Ms. Regan, if I may. I'm wondering what the standard is for painting of pools. Does that count as exterior, or is that not determined? Is it just if there's a substantial reduction?
I guess I'm not remembering that there was an issue of painting the pool. The comment, so the rent stabilization ordinance just says that all common areas shall be painted once every 7 years. I'm sorry, not remember. It doesn't specify. I guess if wherever there is paint, that should be included. I don't know if I know the deck was renovated. I don't know if it was painted. So I'm not remembering the facts.
Okay, well, I don't think it was brought, the issue that was brought, I think, was that it was yellow on the bottom of the pool. And there was also, I want to say the word was cutting, I forget what it was, the area between the pool and the deck, I want to say it was part of the complaint. But I don't think it was necessarily raised in terms of it hasn't been painted within 7 years. So I guess it would have to be raised in that manner. So perhaps there could be relief for the same issue if it were raised with an allegation that was shown that it wasn't painted in the past 7 years, but just for being yellow, I suppose I would agree. And on the pool issue, would uphold the reverse the hearing examiner and agree with the staff recommendation. I also would agree with, I believe it was both the staff recommendation and the hearing examiner, that the exterior needs to be repainted, which the landlord's representative has conceded. There was substantial evidence also to support that the interior paint job was not up to maintenance standards. The landlord's representative has acknowledged that some of the areas had not been repainted. There were photographs submitted. On the odor, I am inclined to remand the issue because there was substantial evidence to support that there was an odor coming from a common area. I don't think there's any reason to doubt the testimony, and of course it's not our job to judge credibility anyways, of Mr. Wood, that there was a smell emanating from the pot. He cannot necessarily know if it was from mold or mildew, so maybe it would need to be remanded to not include those phrases. But if there were a pervasive smell that was a substantial reduction in the housing service as determined by the hearing examiner, I think that's worthy of relief and would need to be remedied. But I would probably remand it because of the mold mildew piece being speculative. And ideally, an inspector from the city would go out to have a third party see if they can figure out what the cause of it is, to be more specific and what exactly needs to be remedied. So that's right.
Vice Chair Topchin?
Thank you. Well, initially, I agree with all the items, but one thing that I was confused initially and I would agree with Mr. Cooper, that the RSO requires to perform the work and doesn't really speak about the quality of the paint job. And that's how the examiner analyzed this particular issue. But since there is evidence of that the work didn't meet the required full maintenance standards, and that's why that $7 reduction, the $33 reduction was reduced to $7 reduction, because that work didn't meet the full maintenance requirements regarding the interior common area. So therefore, I would agree with staff as it as it suggested in that part for the interior common area paint. Initially, as I said, I was confused with the way the examiner analyzed, but now after I did some research and asked the questions, I believe that the recommendation should be affirmed. And I'm going to support the staff's recommendation. Thank you.
I will also be voting in support of staff's recommendation. Mr. Cooper, our ordinances are not about meeting the tenants halfway. Our ordinance state fairly clearly about the standards that must be maintained. In the case of painting, it's basically like for like. So if there was a a very high quality mid-century paint there before, you couldn't go down to a thinned out version from Home Depot, like for like. And it doesn't really make any difference how much you paid for the paint job. It doesn't make a difference to us if you go down to Home Depot and hire day laborers or if you hire a licensed contractor. But if you feel the painting is sufficient, that would be for a compliance determination, which I believe you said you've already filed for. They can determine at that point. The pool yellowing, I would maintain that is not a painting standard. If the bottom of the pool was cracking, and they do have a lifespan, if that was cracking and it was flaking off, it'd be one thing, but if it's just yellowed from the sun and from perhaps the chlorine or whatever chemicals, I don't think that's a standard that I would be looking to address here at the commission level. And as far as the odor, I do disagree with one of my fellow commissioners. I don't believe that the tenant is an expert in mold or contamination. And this would be an issue that could be brought before the county health department. And if they were to suspect there was something, or if they were to determine there was something there, they could order a qualified remediation specialist, but that's not something under the rent stabilization ordinance. So I would be voting in favor of upholding the staff's recommendation. And with that, we have a draft resolution, RSC 20-582. Would someone like to make a motion?
I will do so. I'll make a motion to pass resolution RSC 20-582, resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming in part and reversing in part the hearing examiner's decision in D-44948221 DeLongpre Avenue.
Second.
Mr. Secretary, can we have a roll call vote, please?
Commissioner Charity,
Aye.
Commissioner Kirby's,
Aye.
Commissioner Maggio is not present, Commissioner Martz,
Aye.
Commissioner O'Keefe,
No,
Vice Chair Topshin,
Aye.
Chair Bergstein.
Aye, motion passes. If other parties have any questions about this decision, or really if you have any questions in general about the ordinance and the standards for your buildings, I would urge you to reach out to the city. City Hall is closed, but the direct dial is open. It's 323-848-6450, or you can email staff at rsh@weho.org. Again, it's 323-848-6450 or rsh@weho.org. So both parties, you are more than welcome to attend the rest of the meeting. We're going to mute you and move on to our next appeal. I did leave my glass of water in the other room. Can we take just a 2-minute break so I can run out in the living room and get my water? Yeah, so resume at 7:37.
Commission Secretary, if you can hear me, let's take this moment to bring in Beck Starr and make sure that they want to be in the next item 4430.
Perfect.
And then also test the microphone and video for
Can I, before you do that, can I make a suggestion? If they're
Yes,
not,
please.
if they're not actually parties to the, if they're not going to speak, maybe they can just watch the meeting rather than be in the meeting. But just a suggestion.
That's a good suggestion, Counsel. We have another person, Tara Mitchell-Tree, that wants to do the same. I'm not sure that we've given out the links to where they can watch the meeting. That's on WeHo TV, is that right?
Yeah, yeah, you should be able to view it the way you would a city council meeting.
Yeah, let's let's bring in the parties, Secretary, and then also can you, let's find out if they want to speak. Bring in Beck. Let's find out if Beck Starr, if they want to speak.
Okay.
If they want to watch, then we'll send them to WeHo TV.
Okay.
If they want to speak, at what point would we bring them in? Before the commission deliberation?
We're going to find out if
Okay.
this party wants to provide public comment, or if they want, or if they're a part of this case. We just had the property owner join us.
Okay.
Hello. Okay, and their audio's connecting.
Commissioner O'Keefe. There she is. So we're resuming at 7:37, and we'll go on to our second appeal of the evening, which is D-4430CD 1350.
Sorry, interrupt. We were letting in someone from the waiting room to find out if
Sure.
they were if they were part of the appeal. Beck Starr is connecting to audio now.
Can't tell if she's connected. It's still wiggling. Ms. Starr, can you hear us? Yeah. Ms. Starr, can you hear us? Beck Starr, can you hear us?
Yes, can you hear
Yes.
me?
Yes.
Hello.
Were you wishing to speak on this appeal this evening, or are you just attending?
Either or both.
Which would you prefer, ma'am?
I can speak as well as listen.
Okay. So,
Are
what?
you part of, apologies, Chair, go ahead.
No, go ahead.
Ms. Starr, are you one of the parties in the appeal?
I am. I'm one of the original people from the first hearing with the elevator. Yeah.
Okay, so we have two other appellates with you, so the three of you will be sharing your time. Have you coordinated that with the other parties?
Not really, loosely.
Okay, so we'll bring in the other parties now. I believe that Mr. Tarley is going to begin, and then there is a Mr. LaBallister as well.
Perfect. So I'll just wait until my turn comes around.
Yes, go ahead and mute yourself. You can turn on your video if you like. We have Phil, Mr. Tarley is joining us now. And then let's also let in, and Julian LaBallister is here. And then we have David Milstein. He's connecting, and I believe that he's representing the property owner.
Okay, perfect. Thank you.
Peter, would you like to admit Tara Mitchell-Tree and advise her on how to watch the meeting?
Yes, let's go ahead and do that since we didn't give her that direction at the beginning.
Okay. And we also have one more person in the waiting room. I can't identify them. They may or may not be Joe Goldstein.
Hello, Tara Mitchell-Tree. I just wanted to give, if you could relay this message to Tara Mitchell-Tree. Hi, how are you doing? We're going to provide you, the secretary is going to provide you with a link to watch the meeting on WeHo TV. We can't have you in the meeting itself, okay? So we'll move you into the wait room. Sorry about that communication.
No, that's okay. Thank you so much.
Yeah, so just a moment and you'll get a text from the secretary on how you can find us on WeHo TV, okay?
Thank you.
Okay.
Should we wait just a minute to give her a chance to log on before we begin?
Yeah, and we'll do this relatively quickly. We do have
Okay.
one other person in the waiting room that we should bring in just in case they're part of this case, since we have so many appellates with us on this.
And I'm letting that person in now. They're showing up as admin.
Okay. And I see the property owner representative is still connecting to audio. So bear with us here a moment.
While we wait, why don't we ask admin to identify themselves?
Yeah, that's great. Hello, admin. This is Pete Noonan, the Rent Stabilization and Housing Manager. We are about to hear case D4430, and we wanted to know if you're a part of that case. And I see we have, hello. We don't know, admin, go ahead and state your name.
Hi, I'm David Milstein from Concord.
Oh, great. You know, we have you in two different areas here. So good to know that you're David Milstein. You're showing up as another window here as well. Great. You can hear me all right?
Yes.
Okay. So Chair, you now have all parties on the case.
Okay, we have a full house tonight. So we're here for D-4430 CD, 1354 North Harper Avenue, Unit 116. To all the parties, the way the process will work is our staff attorney, Ms. Regan, will make a report to the commissioners. The commissioners will have the opportunity to ask questions of Ms. Regan at that point. Then we begin. This appeal was filed by Mr. Tarley and Mr. Ballister. I hope I'm not mispronouncing that. As you filed the appeal, you have a total of 5 minutes to speak. And I understand there's some other tenants present. I'm not sure if you want to allocate any time. You may split your time between initial comments, and then if you'd like to hold time for after the property owner has spoken for rebuttal, you may do so. For the parties for the management company, that's Mr. Milstein and who else is here from the, who else is from the property? You will have 5 minutes total, no rebuttal time. I'll ask all parties before you speak, just for the record, state your name and city of record. And with that, we'll begin with our staff report.
Thank you, Chair. In this case, the tenants were granted a rent reduction for the elevator, which was not in good working order. The owner has applied for a compliance determination, and the tenants objected to that application. As a result, the hearing examiner took evidence and asked a city inspector to go out and assess the elevator. An inspection report was provided, which showed that the elevator is in good working order. As a result, the hearing examiner granted the compliance determination and restored the rent. Staff is recommending that the commission affirm the hearing examiner's decision, given that there is evidence in the record supporting those conclusions. Thank you.
Commissioners, any questions for Ms. Regan at this time? Vice Chair Topchin?
Ms. Regan, I have a question regarding the inspection report. Do we know how many times whoever inspected, I believe it was Mr. Noonan, how many times the elevator was used to travel up and down to see if the problems were solved? Do we know that, or because the report doesn't say that?
If it's not in the report, then we don't know that.
Okay, would it be appropriate to ask Mr. Noonan about it?
No, that evidence was not in front of the hearing examiner.
All right, so then the second question is probably not going to be answered also, which I wanted to know if the person stopped at every floor. All right then, never mind, thank you.
Commissioners, any other questions for staff attorney at this time? Then we'll begin with the tenants, which is Mr. Tarley and Mr. LaBallister. There are a number of other parties present. I'm not sure if you want to include them in your time or not. Mr. Noonan, I'm kind of at a loss. This is a first for me. How would do we need to have the parties decide who's going to be speaking? Since they're the two that filed the appeal or the other tenants brought in? I'm a little famish. Thank you.
Those who filed the appeal can begin, and if they want to reserve any time for Ms. Starr, they can do so.
Okay.
Perfect.
So then, Mr. Tarley and Mr. LaBallister, you can begin. Again, you have a total of 5 minutes. You're welcome to reserve time for rebuttal. Which of you would like to begin?
Chair, they need to unmute themselves.
Mr. Tarley, if you can unmute yourself, we can't hear you.
Okay, sorry about that.
There you go. There you go.
My name is Phil Tarley. I'm 69 years old, and I've lived in apartment 316 for 34 years. I have really bad knees. So when the elevator goes out, I either get stuck where I am or I have to stay in my apartment. For over a year, the elevator did not work at all. I had to painfully walk up and down the stairs or stay home. They kept telling me they fixed it, but they're not the ones stuck in the basement or have to climb the stairs with excruciating pain. And I'm not the only one suffering here. Concord came in, they trashed the building on an ongoing basis. We all suffer. Today, I came home from the doctors, the workmen usurped the elevator, and I had to walk up the stairs again with a lot of pain. Now, when the elevator was out
Charlie,
for
I'm gonna interrupt just for 1 second. We can only, you can only speak about what's already in the record. So you're talking about something that happened today. That's new evidence.
Okay.
So we'll give you a few
Okay.
seconds to recoup, but no new evidence, only what is currently in the record.
Okay. The elevator doors on the 4th floor and basement are very old and they need to be replaced. The exposed nails on the hinges and rust all over the inside of the basement door. The doorknob's gone. I have an elevator outage log that goes back 2 years. I will read from a few of the last entries. July 31st, elevator out, stuck on the 4th floor. Sunday, August 23rd, went down to the laundry room with my health caretaker.
I'm going to interrupt, ask and stop the clock. Looking to legal counsel, is this new evidence? Reading of this log?
I believe so. I don't think that was submitted as part of the objection.
So, Mr. Charlie, again, unfortunately, we can't hear, we are an appellate body. We can only consider what is currently in the record. So nothing new.
Okay, well, I've been stuck numerous times outside the elevator when it was out, inside the elevator when it went out. And, you know, I have a lot of knee pain and that's killing me. And I have, you know, I have entries for 2 years back and for all this month and last month when the elevator gets stuck on the 4th floor in the basement and is out. I'm going to yield the rest of my time to Julian LaBallister.
You can unmute yourself, sir. Mr. LaBallister, unmute yourself. There you go.
Can you hear me?
Yes.
Okay, great. I'm Julian LaBallister. I live in West Hollywood at 1354 North Harper. And so basically what we've got is we've got a elevator that's approximately 100 years old. We've got exterior doors that need to be opened to enter into the cabin of the elevator. So the new elevator motor that has been repaired, which is great because now that is functional. The problem is that it is continually going down because the exterior doors getting inside of the elevator are the original doors and they have broken hinges. And I have some video. I don't really know how to share that other than showing my phone on the screen here.
I'll interrupt just for 1 second. Again, we can only consider evidence already in the record. So no new evidence, sir. Just stick to what's already in the record.
Right. So so for that type of evidence for the appeal, that was part of the dispute of why it is not working. So I don't know. I thought that was this hearing was to show that photos of the hinges that were broken on the floor.
We'll stop the clock for about 10 seconds. That would have to be evidence presented at the original hearing. So if you present this now and it was not the original hearing, that video, we cannot consider that. That's new evidence. So
Okay.
how can you present
evidence? Yes. How can you present evidence at the original hearing of what just went down the past 6 weeks? They say the elevator's fixed, but it's not. So how do we prove that it's not fixed? If you
Mr. Charlie, Ms. Regan, can you interject just a second just to clarify this before we resume their?
Sure. So for the parties who, it's important for you to know that the commission is sitting as an appellate body. So they're not actually looking at this anew. They're not looking at this to determine, in fact, whether or not the elevator is working or not. They're they're trying to see what was presented to the hearing examiner and if there was sufficient evidence to support what the hearing examiner found. So if the evidence in front of the hearing examiner showed that the elevator was in good working order, if there was evidence of that.
3 months ago.
Right, that's when this hearing was held. So if something has happened since then that's a different process. That's not this process.
So we have to refile.
Can
We
I
could just-
ask,
Depends on the outcome, yes.
No, Ms. Starr, I'm going to ask
No.
all the parties to take a breath here. Mr. Ballister still has the microphone. Mr. Secretary, how much time do the tenants have remaining?
2 minutes and 16 seconds.
Okay, Mr. Ballister, you have that much time. If you want to yield to another party, you may, or that time is yours, or you may hold some for rebuttal after the property owners have spoken.
Sure. Okay. So yeah, basically a lot of evidence was presented in the original hearing. And that included the doors that wouldn't close properly. So we've got the issue that is still remaining, that the doors don't close. The exterior doors do not close properly, and it disables the elevator either on the first floor or in the basement. So we have broken hinges that are on the fourth floor. We have in order for the door, the exterior door, when it closes, it has a latch that has to latch into a sensor basically to indicate that it is closed. If that doesn't happen, then the elevator itself doesn't go anywhere. So you're stuck. And so the problem is we have these old doors that don't work properly. And that was part of the original problem with the elevator because it wasn't working. It wasn't just the motor, it was continually going down. The original hearing does show that. And so I was going to show some photos of the hinges that are broken and those things, but because that's not in the original, that's fine. But an inspector could come back out to see the fact that there are problems with those things and that these doors are old. So although the motor has been replaced and the motor is functional, which is great because it was down for over a year, it is working most of the time. Then a lot of the other times it's not, and when it's not, I live on the fourth floor, and so it's pretty complicated. And then for Phil, who's got a lot of health issues, it's a real issue. So I mean, it's not a total fixed elevator. The flooring in the elevator, the linoleum that's been put over the flooring in the elevator floor has been put over subflooring that is not stable, and it creaks. There's paint all over it. It's just, I know cosmetics are not what is being reviewed here today, but obviously the interior of the cabin is in a very, very poor condition. And it just goes to show the strips of metal that are holding that cabin together are.
That's your time, sir.
Okay, thank you.
Ms. Starr, can you please mute your microphone?
oh, sure. Let me
No,
see.
Ms. Starr, there's no time for your time has been allocated. So go on to the landlord. I know we have Mr. Milstein, I believe, is with us. So just state your name and city of record. You have a total of 5 minutes.
Okay. Good evening, everyone. I think everyone really understands.
Just state your name and city of record, sir.
Oh, sorry. Hi, I'm David Milstein from Concord.
Thank you.
From the management. Okay. So yes, we had there was a rent deduction a couple years ago before we had management of the building. We bought the building mid modernization of the elevator. We finished the modernization. It was a long process. With elevators, it takes a long time to get the parts. They all have to be custom made. And we got it done and we got it fixed. I asked for a rent deduction removal. Took about, I don't know, 3 months or so to get someone out there. We finally got Peter Noonan out there. I walked the elevator with him. We stopped on every floor. He took pictures of the elevator on each floor, showing that it's working and going up and down on every single floor. That's for Vice Chair Chapsy, and your question. He did, in fact, take pictures of each floor. Other than that, again, I can't use this as evidence, but I do have a letter from the elevator company saying that everything's in working order. And if it's been down at all since the elevator was up and running, it's been for alarm issues and whatnot. And that has been fixed, not in regards to the actual working condition of the elevator. We also had obviously the elevator approved and signed off by LADBS or whoever the state who reviews the elevator. It's approved. We have a permit up in the elevator from them that it's approved and in working condition. Other than that, I don't have much to say.
Commissioners, do you have any questions?
Can Beck?
Mr.
Sorry.
Tarley, I'm sorry. Mr. Tarley, I'm sorry. You used up your time, allocated your time. Mr. Secretary, can you make sure that all the parties are muted at this point, please?
Yes.
They're called upon. Thanks. Commissioners, do you have questions for either party? No questions? Then we'll go into commission deliberations. Commissioner Charity, would you like to begin?
Sure. I'm supporting the staff recommendation affirming the hearing examiner's decision. Unfortunately here, we do have an inspection. We have substantial evidence that was in front of the hearing examiner to rule the way they did. Being an appellate body, if there is substantial evidence, we can't overturn that decision. However, of course, I am moved by the tenants' appeals and presence here. So I am in favor of waiving the waiting period for them to refile if there are present problems with that elevator. And that's it for me.
Commissioner Kerpes?
I would absolutely agree. I just wanted to kind of expand on that a little bit. We are limited to the evidence in front of us. And what's in front of us is that after the original hearing, when you were granted your the rent reduction, the hearing examiner left us with the conclusion that in order to have the reduction restored, the landlord would have to repair the elevator and take all acts reasonably necessary to perform this maintenance. And that's all they said. We don't have much to go off of there. And so when they went for their inspection, and in this case, we don't always have the benefit of this, but in this case, we actually had a city inspector out there that gave a report and talked about going through each floor during the use. Do the outer doors close completely? Yes, outer doors close completely during the use. Does the elevator get stuck between floors? And I know that can change at any time, but when the inspector was out there, it did work. And so when there's a document like that in the record, I would be surprised what evidence you could have to convince a hearing examiner something otherwise. And so we're limited in what we're looking at here, and we don't see where, or I don't see where the hearing examiner made a mistake here. I don't think that you're incorrect that the elevator is not working properly all the time, but unfortunately we can't, that's not what we're deciding here today. And I agree with my fellow commissioner that if there is an issue, I think that we should waive the 6-month waiting period should the elevator become a problem again. That's all.
Commissioner Martz?
I would agree with my fellow commissioners on this one. I want to commend all of the parties. I know that coming to speak, especially on Zoom, is a little bit scary, confusing, and trying to understand all the legal mumbo jumbo can be confusing. So when we stop you or interject, it's not that you did anything wrong, it's that this process can be a confusing one. And I'm sure my fellow commissioners still don't have everything down in terms of the rules. I certainly don't. So don't take offense to that. I fully agree. I think the hearing examiner made the right decision based on the evidence in front of him. Given the testimony and the photos, I don't think that this elevator is properly working, but we're only here to look at whether an error was made by the hearing examiner. I don't think there was. So given that, I would fully support waiving the 6 months. I know it's an arduous process to have to refile, but I think legally that's the correct way to go about this.
Commissioner O'Keefe?
I agree with my fellow commissioners. Somewhat regrettably, we do have the inspection from Mr. Noonan. That was just one point in time though, so I'm a little concerned that any inspection of elevator, if it shows it's working at one point in time, even if it's working 90% of the time, if it's not working 10% of the time, that's a horrible imposition for people's mobility. And I'm, of all the things that come before us, not having a working elevator when a person's disabled is among the most egregious. That's extremely important that they be maintained in working order for accessibility. That said, as a appellate body, we do have to defer to the hearing examiner. We don't rejudge the evidence if there's substantial evidence to support it. So I would reluctantly agree, but I would definitely want to waive the 6-month filing period so that any continued issues could immediately be grounds for filing a new petition for rent reduction.
Vice Chair Topchin?
Thank you. I'll be quick. I agree with everything that I've said, the examiners, commissioner said before me. And the commission's job is just to review the evidence and
Mr. Topchin, if you can step closer to your microphone.
yeah, sorry, apologize. The commission's job is to review the evidence and the record and to make sure that there is no error in the examiner's decision. And I believe the examiner's conclusion is correct. And also, I'm really glad to see the inspection was conducted by the city's inspector. For this type of cases, it's a huge benefit to have the inspection report because that's a neutral, a third party that would observe and attest to the fact whether the issues were corrected or not. So I have no reason not to trust the department's inspection report. And thank you, the landlord's representative, for the clarification on the earlier question that I had regarding whether the inspector stopped at every floor. However, clearly there is an ongoing issue with this elevator. People, I believe the testimonies they're not exaggerated, and since the building is occupied by people who have medical issues and maybe seniors, I do believe that we need to waive that 6-month waiting period to allow the tenants to refile if something goes really bad, because we're talking about the elevator service. People who have bad knees or medical conditions or seniors, they can go up and down carrying the groceries. It's impossible. If the elevator breaks down tomorrow, they should have an opportunity or a chance to refile. We just in the prior case, we spoke about meeting the high maintenance standards. So let's apply the same standards for this case. And I believe the elevator services are very crucial, important services for the buildings that they have that service. So therefore, I will support the staff's recommendation if we waive the 6-month waiting period. I hope the commissioners will support me on this. Thank you.
So first, I just want to echo some of my fellow commissioners. You know, I apologize for the interruptions. You know, pre-COVID, when we were meeting in person, the group of tenants would kind of gather at the podium and just pass the microphone back and forth a little more smoothly. We're still kind of learning our way how to do this via Zoom. So I apologize if I stepped on any toes, but the process is a learning process. And also, you know, I can't speak for the entire commission, but for myself, there are lots of questions I would love to ask during an appeal, but they all lead to evidence that is not in the record. It would be all new evidence. So while the questions might be interesting to me, or I think that might be interesting to the commissioners, because it's not in the initial record, you know, we're not allowed to ask those questions. Mr. Charlie, I feel your pain. I have bone-on-bone arthritis in my right hip, putting off a replacement for as long as I can. If I lived in a multi-story building with no elevator, it would make my life extremely difficult. So I get that. So I'm going to be in favor of what my other fellow commissioners have mentioned, that in favor of staff's recommendation, but we will waive the 6-month requirement so that if this issue continues, you don't have to wait 6 months to bring another action before the city.
I just want to point out that the 6 months has already passed because this is coming to you on a compliance determination. So they can refile at any time.
Oh.
And I'd also like to point out, this is also, if the elevator is not working, they should call code compliance as well. That's a code compliance and issue as well, if indeed the elevator is not functioning.
So you're saying we do not need to amend the motion or to reflect the 6-month waiving? Would that be correct?
Correct.
Okay. So with that, we have a draft resolution, which is RSC 20-583. Would somebody like to make a motion?
I'll make that motion. A motion to pass resolution RSC 20-583, a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming the hearing examiner's decision on D-4430CD, 1354 North Harper Avenue.
Do we have
And
a
I will
second?
second that.
Thank you. Mr. Secretary, can we have a roll call vote, please?
Commissioner Charity,
Aye.
Commissioner Kirkes,
Aye.
Commissioner Martz,
Aye.
Commissioner O'Keefe.
Aye.
Vice Chair Topshin,
Aye.
Chair Bergstein.
Aye, motion passes. If either party has any questions about this, while City Hall is closed, our phone lines are still open. The direct dial for rent stabilization is 323-848-6450, or you can email at rsh@weho.org. Mr. Noonan, do you by any chance have the direct dial for code compliance handy that we could provide at this point? I don't have that number in front of me.
I'll pull that up. Just give me,
Okay.
I'll provide it in my comments
Okay.
later.
Okay, thank you. And parties, you are welcome to remain and view the rest of the meeting, but we are going to mute you at this point. With that, we go on to item 10, new business. I'm not aware of any new business. Item 11, public comments. Mr. Secretary, do we have any members of the public who would like to speak?
Not at this time.
Okay. Item 12, commissioner comments. Commissioners, any comments at this time? Item 13.
Oh,
staff
sorry.
com-
Yes,
Somebody
can you
raise
hear
their
me?
hand? Yeah.
Yes, me, sorry. I just want to remind everybody that we only have a few more days until the census, to the last day of the census, which is September 30th. Our response rates are still low. We want to increase them as much as possible. You can respond to the census by going to 2020census.gov. And the other thing I wanted to mention was a new website that is being put out by the state of California, California Department of Real Estate, which talks about AB 3088. That's the new law that the eviction protection with COVID. You can go to housingiskey.com. Again, that's housingiskey.com. And there is a interactive, it'll take you one question by question through your situation and will let you know in a complete report that it'll do just personalized for you in what your protections are under 3088, AB 3088. But again, you should check with, if you live in West Hollywood, you should check with City Hall first for any detailed stuff. But if you're just generally looking at what 3088 does and protects you from, go to housingiskey.com. It's a really simple, like 10, 12 questions. Kind of depends on how you answer as to whether, how many questions it is. But it's a great tool, and they're going to be adding to it over the next couple of days and weeks, more resources for both tenants and landlords. Again, that's housingiskey.com.
Mr. Kirby, I'll put you on the spot just for a second. And I know it's not directly related to rent, but there was an article that the state is doing a fairly major revamp of the EDD, the unemployment computer system. Do you have any, because I know it's been a stigma point. A lot of people have had a lot of trouble filing for unemployment.
Yeah, there's a lot of changes happening right now. Actually, right now, there's a 2-week down period. No one can apply for benefits at this time. You can apply for benefits on October 5th. If you need to apply for benefits in the meantime, you can still go on there, enter your name and email address. They'll contact you when they're able to. You won't lose much time. I think it's only like a week difference. And the new system, what they're converting everybody over to now is going to be a much better system, knock on wood. And it'll be less manual work for the employees, which then speeds everything up for the millions of applicants that the state has processed. I think the state has received over 8 million applications. They've got a backlog of unpaid applicants of about 1 million.
Wow. Let's hope they can work through the backlog quickly. Go on to staff comments. And Mr. Noonan, can I ask, I know that City Council clarified some of the directives on eviction protection at Monday's council meeting. Are you able to do a brief summary of that? I think it's along with state law.
I could, I'd like to see if legal counsel would like to provide
Okay.
that summary.
Sure.
Thank you.
And in fact, I was going to say, if the commission would like a more in-depth presentation, we can certainly schedule that for an upcoming commission meeting. But in a nutshell, the ordinance and the new state law are complementing each other. So our eviction moratorium is now going to expire. The expiration date of September 30th remains in place for evictions for non-payment of rent due to COVID. At that point, the state kind of steps in, and then from that date until January 31st, if a landlord serves you with what is now a 15-day notice as opposed to a 3-day notice, the tenants provide a declaration as well as 25% of the rent. Now that 25% of the rent, if they can't afford to pay that immediately, they can, the actual due date is January 31st. In our ordinance, we did extend the limits on other grounds for eviction other than non-payment of rent due to COVID. There are still only 4 permissible grounds for eviction, and those limits are in place through January 31st. The other important thing to know is that the repayment period for the rent that is deferred, that a tenant is able to defer due to COVID, West Hollywood tenants have 12 months from the expiration of our moratorium to pay that back. So that repayment period is October 1st through September 30th of next year. I'll just say one other thing that the state law does is that deferred rent can no longer be the basis for an eviction. So even if tenants are unable to repay that at the end of the 12 months, the landlords can move to collect that, but it would be what's called consumer debt, and they'd have to take the tenant to small claims. So the tenant wouldn't be at risk of losing their home because they were unable to pay the deferred rent. Those are kind of the big elements of this. And as I say, I'm happy to present some more detailed information. I want to also commend Peter and his staff. They have set up some information seminars. We're going to do a webinar next week. They are putting information up on the website. And so we are already rolling out information to West Hollywood tenants so that they know what their rights are. And Beck, of course, is on board. The City Council also renewed the eviction defense program. And so we're working closely with the Beck attorneys to make sure that everyone is on the same page and that the tenants are protected and the landlords are aware of what everyone's rights and responsibilities are.
So it sounds like a lot of changes and clarifications, but there are resources both with the state website Commissioner Kirby's mentioned, and of course our own rent stabilization staff is available for tenants and landlords if they have any questions. Would that be a good summary of resources available locally?
Yes.
Yeah. Thank you so much.
And, just to plug that we do have that webinar scheduled for next Wednesday, September 30th. It's at 3:30 p.m. and you can find information on the city's calendar.
Ask my fellow commissioners, would we like to agendize a more full discussion from Ms. Regan on the eviction moratorium laws? I would certainly be in favor of that. Crickets chirping.
I'm fine with that.
Okay. Commissioner Kirby's?
Yes.
Vice Chair Dodgen?
I'm
Yeah.
fine. Yeah.
Okay, so if we could try and get that on agenda as soon as we fit in, that'd be terrific. Thank you, Ms. Regan. Mr. Nooner, do you have any further comments?
Just like to share the code's phone number and then access. There's 2 ways that someone can access code. There's their phone numbers and their email, which is phone number is 323-848-6516. That's their complaint line. They also have it's code at weho.org, CODE at weho.org. The second way that someone can access code is by filing a service request, and that's at weho.org. Under services, there is a service request function that you can select property maintenance and then go ahead and file your request through that app.
Thank you. Commissioner Keith, did I see your hand raised? Yes.
Yeah, just since we were talking about the eviction moratorium and the requirement that people pay 25% at the point that state law kicks in, I just was wondering if Mr. Noonan or Ms. Regan could say another plug about the assistance program that West Hollywood has and how that works.
Yeah, we really encourage anyone who's interested to go to our website at weho.org and click on the banner that says coronavirus at the very top of that page. Under that coronavirus page, there's a number of resources on the left-hand side, and resident resources lists a number of different available resources to any residents in the city of West Hollywood, one of which is financial assistance for renters that are struggling with their rent payments. So we do have some availability of grants. I'm not sure what amount is left remaining in that budget. We do also have free interest-free loans that I believe are good up to 1 full month's rent. So I would encourage anyone who is struggling right now and is in need of some resources, please visit our website at weho.org and click on the coronavirus banner. On the left side, select resident resources.
Thank you.
And with that, I'll just say we're coming up on Yom Kippur. So I hope we are all inscribed in the book of life for another year. And with that, I will adjourn our meeting until our next scheduled meeting, 7 p.m. Thursday, October 8th, 2020, via teleconference. Adjourned. Thank you.